Alright, let's talk about rights, specifically the idea of equality of arms. Now that sounds like something you'd hear in a particularly nerdy Dungeons & Dragons campaign, doesn't it? Hark, good sir, I demand equality of arms before we duel. But it's a real and frankly very important legal principle. In a courtroom, it means both sides, the prosecution, the defense, should have a fair chance to present their case. No one side should have all the good evidence, all the resources, or all the time, while the other side gets a paperclip, a half-eaten bag of crisps. It's about balance. One side can't have a cannon while the other has a spork. That's not a trial, that's a foregone conclusion. This principle is the bedrock of what we call a fair trial. Imagine you're accused of stealing a truly absurd number of garden gnomes. The prosecution has a team of high-powered lawyers, forensic evidence, and a PowerPoint presentation that would make Steve Jobs weep. You, on the other hand, have a lawyer who got their degree from a cereal box whose only defense strategy is to repeatedly shout objection at potted plants. The concept of equality of arms exists to prevent that exact scenario. So where did this radical idea come from? Well, a lot of it was cooked up by thinkers during the Enlightenment, who were all about questioning authority. Let's start with John Locke, a man with fabulous hair and even more fabulous ideas about government. Locke argued that people have natural rights. Life, liberty, property. These aren't gifts from a king. You're born with them. He said people form governments to protect these rights. The government works for us, not the other way around. If a government violates those rights, it has broken its contract with the people. What happens when that contract is broken? Locke said the people have the right to resist, more than a right, a duty. When rulers become tyrants, they're in a state of war with the people, who then have the right to resume their original liberty. Revolutionary stuff. Philosophical permission to overthrow oppressors. He didn't write a treatise on guns, but the implication is clear. You can't resist a tyrannical government armed with muskets if all you have are pointed sticks and harsh language. The ability to resist implies having the means to do so. Now let's address a quote that gets thrown around a lot, often attributed to Jefferson. If a law is unjust, a man is not only right to disobey it, he is obligated to do so. It's a powerful sentiment, isn't it? The idea that your conscience can override a bad law and should. The only problem is, Jefferson almost certainly never said those exact words. It sounds so perfectly Jeffersonian, we've all just collectively agreed he must have said it. A historical Mandela effect. But even if it's an internet fabrication, the idea is pure Jefferson. The spirit aligns with everything he believed. He championed the people's right to question, challenge, and, if necessary, defy unjust authority. He trusted the common person's judgment over institutions. Look at Shays' Rebellion, an armed uprising by Massachusetts farmers. He wrote, "I hold it that a little rebellion now and then is a good thing, and as necessary in the political world as storms in the physical." This ties to law and justice. A law isn't legitimate just because a legislature passed it. Legitimacy comes from fairness and alignment with natural rights. An unjust law is a contradiction in terms, an act of violence, not law. History is littered with examples. The Fugitive Slave Acts, the Nuremberg Laws, apartheid laws. Following that logic, people who defied these statutes were acting on a higher moral principle. Legal cases have wrestled with this for years. In District of Columbia v. Heller, 2008, the Supreme Court affirmed that the Second Amendment protects an individual's right to possess a firearm for traditionally lawful purposes. For example, self-defense within the home. The majority opinion, written by Justice Scalia, focused heavily on individual self-defense. He also delved into history, acknowledging the amendment's origin in fear of tyranny and the need for a militia of the people. The opinion recognized the right was not just about stopping a burglar, but rooted in a deeper political tradition of citizen empowerment. Today, this is an incredibly fraught and difficult issue. The link between the anti-tyranny argument and modern gun violence fuels intense debate. It's a messy, complicated, and deeply American idea. Now, for a hard left turn, I want to talk about Antonio Vivaldi. Yes, the Four Seasons guy. He wasn't just about pastoral concertos, he also wrote operas. In Tito Manlio, there's a stunning aria, Combata un gentil cor. It's sung by a torn character who ultimately resolves to fight. The lyrics hit the heart of our theme. Let's look. It's beautiful, I promise.
Combatta un gentil cor la legge ed il rigor. Quando nel trionfar virtù prevale. Da forte mai sarà mostrarsi convinta, non pronto a contrastar con forza eguale.
A noble heart fights the law and authoritarianism when in the triumph virtue prevails. Strength will never be shown through cowardice, not being ready to fight with equal force.